Certainly one of South Africa's longest running court cases, and reliving their testimony in court yesterday around the moments of Senzo Meyiwa's death. Let's bring into the conversation, always good to get the thoughts of legal analyst. It's Mpumelelo Zikalala making time for me this morning. Mpumelelo, morning. So evidence being led there, a lot of detail from a very, very long time ago. And I'm not sure if you would agree, but I imagine that the prosecution are going to have a field day with this. They're going to start poking holes into this being so many years ago. How can someone remember that kind of detail? You agree with me? Good morning.
Good morning to you and also to your viewers. Yes, I do. In fact, it's not only the longest running, one of the longest running court cases. The only investigation side has been going on for plus minus 9 years before we were able to see people going into the dock. And they're certainly going to have an impact, a number of witnesses, on the quality and the quantity of evidence that they're going to bring, especially from the side of the state. Remember, the state has a burden of proof to prove beyond reasonable doubt that the individuals that are there are indeed the ones that committed the act. Now, if you're not able to do that due to your witnesses coming in with evidence which is not really that credible, or evidence that is easy to poke holes on, it makes the work of the defense much, much easier in terms of saying, Judge, we're going to have no choice than to find our clients not guilty due to the nature of the poor quality of the evidence that has been brought here. Now, this is the second witness that was in the house. Now, that's the scene witness person who would have identified on a first-hand basis the intruders coming in. I would have suspected that police would have conducted your identity parades back at the time, so that you don't have to identify the accused when they're in the box, and all the other evidence which is linked to it, like your forensic evidence, your fingerprints and analysis of guns would have been done at that particular point in time. If you haven't done so, then it makes it difficult, especially for this witness who has to remember what happened on that fateful night, plus minus 9 years ago.
When you take a listen to the testimony from Twala as well, at some point, if I remember correctly, and I don't want to misquote, so I'm not going to try and quote it, but saying that he had avoided trying to go to the house of Kelly Khumalo's mother. It's not so much the part of the testimony I'm interested in. I want to get your thoughts, Mpumelelo. Kelly Khumalo's name being mentioned an awful amount here, but if I understood correctly, unless it's changed, I may have missed this, there's no intention to call Kelly Khumalo. That seems rather odd to someone like me who's not a trained lawyer. The name's being mentioned, but we're not hearing about her coming forward or being called in.
Now, we have to look at it from two sides. Let's start with the side of the prosecution. The value of the evidence, or the weight which is going to be attached to the evidence, is not determined on the individual's name. So whether Kelly Khumalo or Zani Khumalo comes in, what the court would want is that a person who was at the scene on that day, what did they see? Are they able to place the accused which are in the box inside that particular scene? And the sequence of events, is it the same for everyone, so that you can see that they're speaking the truth and the sequence of events doesn't change? So if that evidence was brought in by Zani Khumalo, or was brought in by Kelly or any other person who was in the box as they are now, the court is not going to say, because it is spoken by Zani Khumalo, let's place more weight on it in terms of its probability. So I think that's where the state was probably looking at. Or the second reason could be, since you are being implicated in a number of other things that we will not be able to explain, I'm not going to take you to court so that you are my witness and provide or poke much more holes or make the evidence which I'm supposed to bring in the state weaker. So I'm going to leave you behind Kelly Khumalo, because I can see that you are not going to assist in this case in a much, much good manner. However, the other individuals that are in the house, if they can come in and say, yes, on this particular day, the following sequence of events happened, it led to someone dying, and that's an individual being Senzo Meyiwa, then I'm going to come back with the conviction that I'm looking for. So we must look at it from that context, on a technicality basis, and not on the individual itself, because whether she comes in, another person comes in, the court is not going to place much more probable value of what Kelly Khumalo is going to say. The court is simply going to say, I want to know of the individuals that were in there, regardless of their reputation in society, on what media impact they might have.
I want to get your thoughts as well, because I actually haven't spoken to you since we heard from Sergeant Moses Mabasa and Mpumelelo about this cell phone data. These analysts, also Lambertus Steyn from last week, in the beginning when they obviously being led in evidence, it sounds very damning. It sounds like napalm and bombs being dropped in court. But when you start unpacking it with the defense lawyers, you begin to realize it's not actually all that credible. I mean, even yesterday we had this issue of the one one cell phone, I think it was of accused number 3 or allegedly of accused number 3, had a photo of a man with dreadlocks, only to then find out later the photo of the man with dreadlocks actually isn't one of the accused. It's not painting a very good light and a very good picture for me on the trustworthiness and admissibility of cell phone data in court. What did you make of all of that?
Well, you have to look at it within this context. You see, when it comes to the admissibility, it works perfectly because it is independent evidence brought in by individuals that are not there, that have no interest in the matter. But what you must prove with the cell phone evidence is the nature of the relations between the co-accused and anyone that you want to bring into the fore, the nature of being able to communicate and strategize or plan the crime that allegedly took place. Now, if you can confirm that there's been communication between party 1 and party 2, you may not know the context. However, the frequency and the number of times in which they've been able to communicate with one another and the duration of those frequencies then becomes important. But then you must marry the two with whatever story that you come up with or the motive that you are coming up with in the motivation of the crime being committed. I think what's the stage where it was perfectly or did perfectly was to introduce this evidence and say, yes, there is communication. But what it failed to do is to marry that communication to the results that happened on that day. So, yes, people may communicate on a daily basis. You and I would probably get wrong numbers in the next 2 weeks. And people are going to say, I'm sorry, I called you by mistake. We're going to get telemarketers in the next 2 weeks. But it does not mean that we've been conspiring and planning with them on whatever that they need to do. So the state in marrying that type of communication with the motive of what happened on that day and the results of such, I think the state failed to be able to prove that. But most importantly, if you have any inefficiencies or any deficiencies in your evidence, it is rather better if it's brought in by you. So it was supported by prosecution to then say, what does this information mean? Can you draw an inference that there was communication between the parties? Are you able to identify any of the things that are there? If you are going to identify people within the pictures, then go and conduct identity parades, because that's a proper manner of being able to identify individuals in ascertaining whether those are identities in which you're attaching to them. It rests on you as a state to be able to prove that these individuals are indeed guilty. And I don't think that assisted the state in any manner. The only thing that it showed is that the state tried to investigate to the proceedings. However, they're not doing the tying up or the tying up the loose ends or the loopholes in order to make sure that you're able to come back with a conviction.
Oh, that's actually a very clever analysis on what they did there as well. So they introduced it, but they didn't tie it together because they don't want the defense to come back and make it seem like the prosecution actually doesn't have this tied up. That's very well picked up in Mpumelelo. I would never have noticed that. And Mpumelelo Zikalala, that's why we talked to him. Legal expert giving us his thoughts this morning here on eNCA. Of course, the Senzo Meyiwa murder trial going to continue later this morning, live streaming on eNCA.com, of course, and regular updates here on the channel as well.